Welcome to this series of webinar. Good morning, good afternoon, good evening, wherever you are in this interesting planet. We are really delighted to have this third series built on two previous ones regarding the intellectual property protection and the intersection with traditional knowledge, genetic resources, as well as traditional cultural expressions. The first one was organized in 2020 with a very close collaboration of WIPO, and we highly and ever appreciate their permanent support. In the 2022, we organized a second one jointly with ACIPI, who are very close to APPI. They have a collaboration agreement. And the first one provides an international overview about this complex issue of traditional knowledge, genetic resources, as well as traditional cultural expressions. In the 2022, we focus in Latin America, the challenges that face the region and how it should be built on the adequate protection. But this year is especially important because now we focus essentially with APPI and ACIPI in this program in Europe, in an agenda in Europe, but also with some specific interesting in this year, because now, as you may know, in WIPO are discussing an interesting possible draft of international treaties for the protection of the TKGR and TCEs. So for us, it's quite important to have you here to listen to the experts about this event. So I welcome all of you. I appreciate thanks to ACIPI for this joint effort, as well as WIPO, who has also participated. And I hope that you really enjoy and learn and have experience. Thank you. Matthias.
Hi, everyone. This is Matthias Nottinger from Secretary of ACIPI. We are very happy to have this cooperation agreement with AIPPI. It was signed last year in AIPPI's Congress in San Francisco. And as Martin said, we had a first series of webinars, of four webinars last year. And this is a continuation, more from the European side or point of view. So we thank AIPPI for joining forces with ACIPI in these very important topics. These are very important topics for ACIPI, and so we are very, very proud. I also want to point out that we received a very kind invitation from AIPPI to participate, to organize a webinar last week that is called Scan the Globe, which gave us the opportunity for 4 speakers of ACIPI to give an overview of our region and the developments and the news from Latin America. So we are very thankful for that as well. And so, as I said, we are very proud of this collaboration. We hope it will continue to grow and to have initiatives like this. I want to thank Martin also, because he's a part of AIPPI, and as a former president of ACIPI, he was a key factor in the organization of this series. So thank you, Martin. And well, welcome. I hope you have a great activity, a great series of four webinars this month or next month. And I also want to remind you that today expires the early bird for the registration of our seminar, which we will take in Quito in June. I believe they will address this at the end of the webinar, but I don't want to leave the opportunity to communicate this to you and to invite you to join us. There will be a great program. So the best of lucks, and thank you very much.
Thank you, Matthias. And as you see in the screen, this is a calendar of the series of webinars. And today we begin with the first one, the European Union Legal Framework for IP Protection of Genetic Resources. And as you will see, we have three experts, and will be moderated by Professor Takeshi Komatani. He is head of the subgroup of the Genetic Resources Committee of AIPPI, very active, and he's an IP litigation certificate patent attorney in Japan, and currently a principal of the Chemical, Pharma, and BioLife Science groups at the IP law firm in Osaka. and served as IP counsel for academia, SMEs, and big pharma domestic and overseas. He received his PhD in pharmaceutical science from the University of Tokyo and qualified as a Japanese licensed registered pharmacist with a certificate of Campo Natural Medicines. He also received an LLM, certificate in intellectual property from Keio University. If I describe all his academic activities, we will not finish. I'm very proud to have him as a moderator of this webinar, a member, the head of the subgroup, because his characteristic enthusiasm put many things together. So I pass the floor to Professor Komatani. Takeshi, thank you. Go ahead. The floor is yours.
Thank you very much, Martin. My name is Takeshi Komatani. Thank you very much for your kind introduction. I would like to begin with today's this year's webinar series. First of all, as a housekeeping matters, please be in mind that there will be a Q&A session at the end of all presentations. Not really all, but we are having a case study. So at the end of the presentation, and questions to the speakers should be submitted via Q&A function, as you can see here. And then for the technical problem, please send a message by the chat function to AIPPI events. And recording and the slides from today will be available upon request. Please make notes of this email or address. And translation available from English to Spanish and Spanish to English. There is a brief survey after the webinar. Thank you very much for your feedback. So we'll move to the introduction of today's webinar. So I would like to start with the introduction of the 4 speakers, including me. I was already been introduced, so I will start with Begonia Venero, who is from WIPO. She joined WIPO in 2008. She's a senior counselor at the Traditional Knowledge Division of WIPO. She received a law degree from Pontificia Universidad Católica del Perú, Lima, in Peru. And a diploma in international studies and industrial property from the Center for the International Intellectual Property Studies, CP, and Robert Schuman University, Strasbourg, France. Before joining WIPO, she chaired the Intellectual Property Board of Appeals of the Peruvian National Institute for Defense of Competition and Protection of Intellectual Property, and the National Commission Against Biopiracy of Peru. And she also lead author of Protection and Promote Culture and Blah of the many literatures. I would like to hear some of the knowledge from his experiences. Next, Fleur Twiningen Westerhuis. Fleur specializes in she's from a Dutch law firm. She specializes in technology-related intellectual property matters with a focus on patents and plant varieties. In her daily practice, she represents a wide variety of domestic and international companies that are active in technology-intensive business sectors such as agri-food and biotech. She's an experienced patent litigator, is one of the only handful of lawyers in the Netherlands with extensive experience in litigation related to the national and the community plant variety rights. Furthermore, she has experience in leading multi-jurisdiction litigation team and assists clients in implementing outcome seizures actions based on EU anti-piracy regulations. She has more than 18 years experience and litigating various cases. So we would like to get some experience opinion on this case study. Last but not least, Daphne Ramos from Peru. Daphne is a lawyer from the Universidad Nacional Mayor de San Marcos from Lima, Peru. with a postgraduate studies in patents, and she has also a master's degree in business administration from Universidad Peruana de Ciencias Aplicadas, and has studies in management and administration at the EOA Business School in Spain. She has more than 15 years of experience in intellectual property and industrial property and innovation management matters, as well as issues relating to commercial advertising, unfair competition, and consumer protection, having developed her professional career both in the public and private sector. She is a part of the Peruvian team in the PAI program of assistance to inventors developed by OMPI or WIPO. She is a mentor in Peru in Liquid Venture Studios and Acceleration Program for emerging food and beverage brands. So we'd like to probably obtain various kinds of opinion and comments on from the professional point of view. Now, I would like to move to the real session from the Begonia WIPO, an introductory presentation. Begonia, floor is yours.
Thank you, Takeshi. I would like to thank AIPPI and SCP for the invitation. I'm very happy to be with you today. I'll try to keep my presentation short because you'll see that the case study is really interesting. So I'd like to allow sufficient time for the case study. I'll share with you some of the recent developments at WIPO on intellectual property, genetic resources, and associated traditional knowledge. The next slide, please. And before beginning my presentation, I'd like to just briefly mention some of the things that we do at WIPO, and specifically the traditional knowledge division. We have 7 different service areas. I'll talk mostly today about facilitation of international negotiations. That's one of the service areas, but we do a lot of other things also. We have a very interesting community entrepreneurship program. We support indigenous women from different places of the world who have community enterprises based on traditional knowledge and traditional cultural expressions. And actually, if you can see my earrings, they come from one of these community enterprises. We also have a global reference on IP and genetic resources, traditional knowledge, and traditional cultural expressions. So you'll see some of the resources that we have put together to facilitate information for those interested on these issues. Next slide, please. So for my presentation, I'll start by speaking on the IGC process in general, the General Assembly's decision and the diplomatic conference timeline, intellectual property and genetic resources, and finally key resources that you can find, you may find useful. Next one, please. About the IGC, the full name is WIPO, Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge and Folklore. That's the full name. The short name is IGC. It was established in the year 2000, so it's been a long time. It's a committee that has been established to focus on the 3 issues, the 3 topics: genetic resources, traditional knowledge, and traditional cultural expressions. Who participates at the IGC? Of course, it's basically WIPO member states, as in all the other WIPO committees, but also we have a very active participation of observers, in particular, representatives from indigenous peoples and local communities. Next one, please. So the IGC receives a mandate from the WIPO General Assembly every 2 years. We receive a mandate for the biennium. And in end 2021, we received the mandate, let's say, normal mandate that we receive for the biennium, which is basically around text-based negotiations with the objective of finalizing an agreement on an international legal instrument relating to intellectual property, which will ensure the balance and effective protection of genetic resources, traditional knowledge, and traditional cultural expressions. In the framework of this mandate, for this biennium, we have negotiating text. We have a negotiating text on traditional knowledge, another one on traditional cultural expressions. We have two texts on genetic resources, and I'll mention it later. I'll mention them later in a little bit more detail. But we have also working documents, submissions, and proposals of member states and accredited observers. Also, based on a decision of, I think it was IGC 43, we have organized virtual activities, and next week, I think we have the last one of the series of virtual meetings related to genetic resources. I think the one next week is about patent disclosure requirements. Next slide, please. So we had the mandate for the biennium, and surprisingly, the next year, in July 2022, there was another meeting of the WIPO General Assembly. And typically during the second year, let's say, or when the mandate for the biennium is already adopted, not much happens at the WIPO General Assembly, but this General Assembly was different. A huge decision, a very important decision was taken at this WIPO General Assembly in July 2022, which was to convene a diplomatic conference to conclude an international legal instrument relating to intellectual property, genetic resources, and traditional knowledge associated with genetic resources. So, as you can see here, the focus is on genetic resources and traditional knowledge associated with genetic resources. This decision is not related to traditional knowledge and traditional cultural expressions. It is related exclusively to genetic resources and traditional knowledge associated with genetic resources. So what was this decision, or what does this decision say? It says that there will be a diplomatic conference no later than 2024, so that's already next year, that the basis, let's say, of the negotiations should be the chair's text, which I'm going to discuss a little bit more in detail later, and that an IGC special session and a preparatory committee should be convened this year in 2023. And we already have the dates that I'll show you in the next slide. Next slide, please. So this is a timeline for the diplomatic conference. Everything is happening very fast. The decision was taken in July last year. We have already set dates for the IGC special session in September 4 to 8, and for the preparatory committee on the diplomatic conference. So the preparatory committee would deal more with the formalities around the diplomatic conference, and the IGC special session. It's a new opportunity, let's say, or a final opportunity to discuss substance for WIPO member states before the diplomatic conference, and so as to define the text on which the negotiations will be based. And we don't have a date yet for the diplomatic conference, so it will be published when the date is available, but it's not available yet. All we know is that it's going to be next year. Next slide, please. So what are the texts that are the main text, let's say, for the negotiation on genetic resources? As I mentioned, the decision of the General Assembly says specifically that the draft international legal instrument relating to intellectual property, genetic resources, and traditional knowledge associated with genetic resources, commonly known as a chair's text, will constitute the substantive articles of the basic proposal for the diplomatic conference. So it's the second text that you can see there, 43.5, who is going to be kind of the basis for the negotiations. But I mentioned the consolidated document because it's a it's a document that has been prepared over the years, and basically in this consolidated document, you can find all the proposals of WIPO member states and accredited observers. And it's not an easy to read document because there are many brackets and there are many options, but it's still interesting to look at it. So if you're interested on these issues, I would advise you to take a look at the consolidated document. And of course, to take a look at the chair's text. I'm going to show you the structure of the chair's text in my next slide. But maybe to start with the objectives, there are basically two objectives in this chair's text, and they are to enhance the efficacy, transparency, and quality of the patent system with regards to genetic resources and associated traditional knowledge, and to prevent patents from being granted erroneously for inventions that are not novel or inventive with regard to genetic resources and associated traditional knowledge. The next slide, please. So in both documents, both in the consolidated document and in the chair's text, there are basically two approaches, two ways of approaching this issue. One of them is the so-called patent disclosure requirements, or specific patent disclosure requirements for genetic resources, and also another approach that could be complementary also is databases, using databases and or other information systems for genetic resources. And you'll see this in the chair's text in the next slide, please. So this is the structure of the chair's text. On the left side, you have like the more substantive articles. On the right side, you have the more formalities related articles. So we're not going to mention those, but there they are in case you want to take a look at them. So there's an article for objectives, another one for list of terms with some definitions, relevant definitions. There's an article on disclosure requirement, another article on exceptions and limitations, another one on non-retroactivity, sanctions and remedies. And then we have the second approach, which starts with information systems. So we have an article also on information systems, which, as I mentioned, was the second approach. And also a couple more articles, one on the relationship with other international agreements, and a review article that states that contracting parties would commit to a review of the scope and contents of this instrument, addressing issues such as the possible extension of the disclosure requirement in Article 3 to other areas of IP and to derivatives, and addressing other issues arising from new and emerging technologies that are relevant to the application of this instrument no later than 4 years after the entry into force of this instrument. That's a review article. Next slide, please. So we have a very good webpage about the diplomatic conference. So if you're interested, you can look at that webpage and find all the information. There's also a summary of the chair's text if you want to take a look at. It's the second document that I'm showing in this slide. A very interesting publication also is the first one on the left side, key questions on patent disclosure requirements for genetic resources and traditional knowledge. And it's kind of a comparative study that analyzes the different laws that are already in place and that already include disclosure requirements. So if you're interested in that issue, it's a good document to look at. And we also have two short briefs, one on the IGC and the other one on IP and genetic resources. And the next slide, please. We also have, for those interested in disclosure requirements, a table that is updated regularly. This is the version from December last year. There are more than 30 countries that have already adopted legislation, including disclosure requirements. Sometimes it's in the patent law, sometimes it's in the access and benefit sharing law. So it depends, or biodiversity laws, but there are over 30 countries that have adopted some kind of legislation, and there's also an instrument adopted by the European Union, and you can find all the details in this table. The next slide, please. This is another document that is not directly relevant to the negotiations, but that can be useful for those interested in intellectual property and access and benefit sharing agreements, which basically deal with genetic resources and associated traditional knowledge. So that's another publication that we have in our website that you might find useful. The next one, please. And it's, I think, my final slide. Yes. So if you have additional questions, you may contact us. That's our email account and email address. As I mentioned, we have a web page that we have put together specifically with information about the diplomatic conference. So you will find relevant information there. And also, if you want additional information about the work that we do, not only regarding the IGC process or the diplomatic conference, but regarding all the other things that we do that I mentioned at the beginning, the other service areas, you can find this information in our website. And yeah, and that would be the end of my presentation. Thank you.
Thank you very much, Begonia, which was very informative and up to date. And we learned a lot from the WIPO side and a diplomatic point of view. Now, I would like to move to the real life professional point of view. So we are going to present the EU legal framework for IP protection of genetic resources, part 1, which is the using the case study. Now, so the case study is which is called Biobricks Europe, which is a biocement strengthened with the microorganisms. So we are going to introduce this case, which is it sounds real but hypothetical, and in the first half of our session, and then we'll give some questions relating to the IP protection and related compliance and regulation issue. First of all, I would like to give you a disclaimer, legal disclaimer, as usual as a legal practitioners. Last but not the least, I would like to focus on the last portion of this disclaimer, which is about the contents of this webinar, which is actually the case study is based on the scientific facts and which is true according to our analysis and survey. But the case per se is some of the combination of the facts, so it's a hypothetical and fiction. So do not take it as a real case, and there might be some error, but we are not obliged to be disclaimed. Now, using this case study, we'd like to focus and discuss about 3 aspects of the IP protection from respect to the genetic resources. The first one is the actual IP protection system around the world, not only patents and some of the other types of IP protection is available for genetic resources. We'll focus on that issue first, and then the second one will be disclosure of origin, which might be related to the patent, which for which the Begonia has partially introduced. And the number 3 is a biopiracy and ABS issue and other regulations related to the IP protection of genetic resources. Now, the reason why we introduced this case study is to understand better using the real scientific and technology cases. Today's topic is something to do with sort of SDGs and environmental issues. As you can see, most CO2 emissions result from the chemical deposition is a problem in all over the world. And then we have analyzed and to find out that about 8% of global anthropogenic carbon dioxide is actually came from cement. And most emissions result from the chemical decomposition of limestone material and the use of fossil fuels, we have learned. Emissions can be reduced by making the production and process more efficient, or using green energy, and or replacing the traditional raw material with something new, bio-based additives. That's the background of the facts. Now, facts will be presented by experts from Netherlands. Fleur, can you explain a little bit more about the facts?
Yes, thank you very much. So this is in fact where our company BioBricks comes in. Again, hypothetical and all fiction. BioBricks Europe is a company that is based in the Netherlands, and it's active in the field of development of sustainable construction material. They have a long-standing collaboration with a Peruvian institute that assists in the collecting and characterization of genetic resources that can be used for the production of biocement. The parties have identified a silica-rich sugarcane plant in Peru. And what you should know, silica is an important component that is added to cement to improve the mechanical strength. Now, this single plant was shipped to Europe and introduced in a breeding program where it was crossed with a Mediterranean variety to develop a new silicon-rich variety that can grow in a Mediterranean climate. So you don't need transport from Peru to Europe, which also contributes to reduction of CO2 emission. The joint development resulted in building blocks that are depicted on this slide. Next slide, please. Now, the biocement used for the building blocks is in fact a blend of traditional cement and biosilica ash, as a result of which they are able to reduce the traditional raw materials, which have high impact on CO2 emission, with about 40%. Now, this biosilica ash is obtained by the combustion of plant residue of this new silica-rich sugarcane variety. And below you see the process of the production. So the plant residue is burned, producing also bioenergy, green energy that is used to the process of the plant. And also it results in biosilica ash. Next slide, please. Daphne, that is you.
Okay, I thought it was yours too.
Okay,
following with the case, and this is the kind of case where we are handling different facts. One of the facts is these sugarcane plants with high silicon concentrate were discovered in an indigenous community named Ancash Urcu San Hilarion that is located in one part of Peru. The name is Ancash, and it was found during the collaboration project between BioBricks and the Peruvian Institute in 2019. Next, please.
Next is my turn, yes. So now the other portion, the biocement, is microorganism used, which was used to strengthen the biocement, which is a new bacterial strain called Spora sarcina. AIPPI ACP sounds very familiar with me. That introduces calcite production. The use of these microorganisms makes biocement self-healing, which is nice nature, like the healing of the bone fractures. The bacterial strain was isolated actually from a material called Masato de Yucca, originating from also Peru. and characterized in the research lab of the BioBricks group. The bacterial Spirosacina APP was selected for its biochemical properties, including rapid calcium carbonate production.
Now here, I'm going to explain you because it is important to know, even though we have mentioned that this is a fiction, there are some things that are real, like the existence of this kind of material. In Peru, and I know we have a yucca with other names in other parts of the world, Latin America especially, masato is it's a vegetable that's came from yucca. Yucca is a tropical vegetable that is formed by a mass of rigid leaves. You can see in the picture, you know, the one that seems to be like a large potato. Yes. In some meals, actually, the way we eat in Peru is sometimes the yucca replaces when you eat potatoes. And you can see in the screen, in the presentation, in Peru and many other places, we produce chips, like potato chips. Yucca chips are actually delicious. But from the yucca, you can obtain the masato. What is the masato? The masato is the beverage you can see at the bottom of the slide. Masato actually is part of many investigations that analyze the relevance of homemade fermented food maintaining traditional indigenous community in a sustainable way. It's a source of isolation of bacteria that could be applied in so many contexts. Peruvian masato is a very delicious liquid made from fermented yucca. You have to ferment this yucca. It's very popular in Peru, especially in the Amazonian zone. To prepare masato, you basically use the yucca, sugar, and water. One of the most important parts of the preparation of the masato is the crushing of the yucca and the fermentation process. Actually, the fermentation process must be done between 7 and 10 days and in a dark place. This is the part that is particular, and I know that it's going to be very interesting for all of you, is that the traditional way to crush the yucca was chewing the yucca actually in the Amazon. This is the way ancestral cultures used to prepare the masato. It's chewing because the saliva contains enzymes that helps to break down the sugar so that they become fermentable. Nowadays, you have another ways to prepare the masato, but this is something that traditionally we used to do and do until now in Peru. Well, and the masato has a lot of benefits that satisfies, for example, hunger. The masato gives you quick energy with a little bit of fat, and it provides to you a lot of vitamins, vitamin C and vitamin B. Next, Takeshi, please.
Thank you very much, Fleur and Daphne. So the facts are very complex and but interesting. That maybe take a long time to understand and analyze. But we have to focus on the IP matters. So we have simplified those facts into one diagram, which is shown here. To the left hand, we have drawn components of the microorganisms. That is from a traditional knowledge, genetic resources related masato de yucca, and the microorganisms here, and then that will produce calcite and some self-healing properties. And the right hand is a sugarcane. Sugarcane is also from Peru, and sugarcane plants is derived from Peru, which is a new variety, and they'll produce a biosilica. And those two components and some of the portion of the organisms constitute the new novel biocement, which is a BioBricks. Now, as the IP practitioners, we are very interested in how this invention can be protected to promote the BioBricks business all over the world without, avoiding any legal issues, especially IP and other biopiracy issues. Now we have three questions, as I mentioned earlier. The most important question as a practitioner is a question number one: IP protection of genetic resources. Now, IP maybe includes a patent, but also many other forms of protection. What forms of IP protection available for BioBricks? Now we have three experts, including me, from three jurisdictions. So before going into the specific questions, we'd like to introduce some of the key factors, key framework of the IP protection in each countries. Now we are having the EU legal framework for IP protection. So we start with the EU. Claire, can you explain
you.
how the protection is?
Yes, thank you. So from a European perspective, the main forms of protection of genetic resources are patents and plant variety rights. Our company BioBrick can apply for a European patent, which is obtained by a centralized application proceeding, and then it falls apart after grant in the famous bundle of national patents. So if there would be an infringement, BioBricks would have to start separate proceedings in every EP country in which it has validated its patents. As of the 1st of June of this year, however, it will be possible to validate the European patent with a unitary effect. So it will be one single right for all participating member states of these unitary systems, which are at the moment 17. In addition, there will be a new European Patent Court that will have exclusive jurisdiction over all unitary patents, but also over the traditional European patents that have not been opted out. So if BioBricks would like to keep things as they were in its patent portfolio, it could decide to opt the patent out. Or alternatively go for national patents in the various countries. Then under the European plant variety rights system, we already have a unitary system based on the community plant variety rights regulations, which is widely used in the breeding industry. And as an alternative, it is also possible to protect it at national level. Next slide, please.
Okay,
Now,
this is the part
for
Peru.
Yeah.
Yes, thank you. Basically, based on the BioBricks case, we have the same systems that the company can use, as Flora mentioned, from Europe. In Peru and in Andean countries, just to mention, are Bolivia, Colombia, Ecuador, and Peru. We have one law, it's an Andean decision. It's Andean decision 486. And the difference that what happens in the EU, we do not have a unitary system. So you have to go for your patent and you have to go to each territory, to each country. This is something we have to have clear. So we have the Andean decision 46, and in Peru, our local law is the legal decree 1075. The applicant, what can do is actually to go through patents, or they can use also the plant variety system. Something that I think we're going to discuss then in the next question, right, Takeshi, is that in the case of Peru, we do have regulation regarding genetic resources and traditional knowledge. That's it. Next, please. This is the plant variety system we have, Andean decision for Andean countries 345, and Peru is member for UPOV. So the procedure and the technical requirements are very familiar to the ones you use in Europe. But I think the plant variety rights is something that is going to be analyzed in the next webinar in my theory, I think. Next, please.
Now comes to Japan as a backup. You know, Japan is like Europe. Japan has two systems, patents and plant variety rights. And Japan has only national patent only, unlike EU. I'm not sure how I should it, but the Andean region is sort of a different system. And member of the Paris Convention and PCT, so you can use, or BioBRICS can use a PCT application designating Japan is a valid application in Japan. And Japan is also a member of Budapest Treaty, and Japan has an international depository system as well as a domestic one. If you want to only deposit Japanese only, that's also possible. But usually, international companies are interested in the international depository system. And also, plant variety rights is available, and Japan is a member of a UPOF of the recently amended 1991 revision has been adopted. So you can also choose plant variety rights. Now that we have explained most of the general framework of IP protection related to genetic resources. Now, I would like to have some discussion session within the three speakers, including me. What is the best, what is the efficient way to protect your BioBRICS biocement system in here? Do you have any idea, or do you have any comments? Fleur or Daphne?
If you want to kind of start, it's okay.
You
As
can
I
start,
mentioned-
yes.
Yeah. As I mentioned in previous slides, actually what the company can do is to go for a patent application. Peru is also a member of PCT, so you can use also PCT system to file the national applications. But something that the company BioBRICS needs to keep in mind is the genetic resources, the protection we have in Peru and mostly Latin America of genetic resources and traditional knowledge. As you know, Peru is very rich in genetic resources because it's one of the major centers of plants and animal genetic resources. Based on that, we are part of many protocols like Nagoya, and we have a local Andean decision. It's Andean Decision 391. And we have local regulations. Actually, our local regulation is very new. It's from 2021. What the experience has shown to Peruvians, because our regulation is that the things are changing, and now we have more inventors and scientists that want to study our local resources. And that is why, in order to use a genetic resource, you can use, depending on the use, again, you are going to have two different kind of authorization. For commercial purpose and for non-commercial purpose. Non-commercial purpose is like the one you want to use for investigation. Basically, it is supposed to be easier to get the authorization. It's not really a contract. It's a kind of authorization because it's not a real negotiation. For non-commercial uses, basically what you provide is non-commercial benefits. The first and the most important is the disclosure of your investigation. Something that it's important to keep in mind is that if you are doing an investigation, but the purpose is a prompt pre-commercialization or commercialization, you cannot ask for this kind of authorization, and you should go to negotiate a contract of access to genetical resources. When you negotiate that kind of contracts, actually in Peru, just to have an idea, we have two. One of them is still under negotiation, and I think that the other one is from the MACA, which is a very important resource from Peru. But when you do that, I cannot tell you that it takes 1 month, 6 months. I mean, according to the law, it should not take more than 3 months. But the truth is that each case is negotiated like that, case by case. So you have to explain the reason you want to access to the resource, and then you have to provide non-monetary benefits and monetary benefits. Normally, monetary benefits are related to an annual royalty of 1%, And you can offer also things like building a lab or things like that. It is part of it. What is important to keep in mind is that you are supposed to ask for the contract of access when you are going to start the use or investigation, not when you are going to file the application. This is something that may happen in some cases. So inventions that include generic resources derived from plants and animals, where Peru is a country of origin, must request the respective access contract. Based on that, it also includes, for example, you in your slide, you mentioned microorganisms. Yes, microorganisms that are resources from Peru needs this kind of contract, in addition of the certificate or deposit, because Peru is part of the Budapest Treaty. As I mentioned, its contract is different and it's part of the negotiation. This is regarding the general resources, which requires a kind of contract. But we also have traditional knowledge. Actually, traditional knowledge is something related, but it's not exactly the same. Actually, a traditional knowledge is that knowledge, innovation, or collective practice from indigenous people associated to biological diversity. That kind of known is very important in countries in this part of the world like Peru, because it's part of our cultural identity and of the indigenous people. Since 2002, we have a law. Is the law, the number of the law is 27811, and this is the protection of collective knowledge of indigenous people related to biological resource. What happened in application of the law? We have incorporated different mechanisms for protection of our traditional knowledge. And we have two different kind of registries. We have a public registry and a confidential registry. You go through a confidential registry when you, as a company, for example, want to use a traditional knowledge that is not in a public domain, actually. And you use the use of the registry that is public is for traditional knowledge that it is in the public domain. And we basically use that kind of registry. I think Begoña mentioned something like that, in order to avoid the registration of patents that do not comply in other parts of the world that do not comply with patent requirements, novelty and inventive steps. Yes.
I have a question about this plant point of view, because our BioBricks is using a new variety that is derived from the Peruvian originate, but it's sort of a new variety. So in that case, you still need some requirement to be satisfied.
Yes, because you're gonna use it, and after that, I think in our case it was you produce a third variety for building blocks, and in that case you can file a plant breeders application. Yes,
but not for patents, or do you still can you also?
No, we do not. Yes, in Peru we don't. In Peru, actually, it's the Andean decision. It's not for just Peru. It's not all the Andean countries. We do not protect plants and animals. The patentability of microorganisms, for example, is actually an exception of our Andean law. In this way, microorganisms existing in the nature or the structure are not patentable. However, what you can protect is when they are modified and provided, and they need to comply with patentability requirements.
I see. So in the case of BioBricks, you need to be very careful in which form you should choose for Peruvian protection, right?
Yes. I think in this case, in our case, it's part of a patent. Actually, no, it's not because it helps to improve the final product. Right. And he's using the yucca and the masato, which is part of traditional knowledge that is related to biological resources too. So you have to be very careful, and you have to know that you need authorizations. I would like to say that in the case of Peru, it's very easy, but actually it is not. The good part is that when you need this kind of authorizations of a access contract, the authorities are very willing to help you because we are in the process of learning actually. So
Okay.
it's very confident. Yeah.
Okay, thank you. I should take the time for Fleur. What about the situation in Europe?
Yes, thank you. Well, in Europe, I think the situation is slightly different. So from a patent perspective, it is possible to patent microorganism or microbiological processes, even if they occur in nature. And the same applies for gene sequences, for example. In that event, you do have to disclose the industrial application, including also the function of the gene. And as regards plant varieties, as such, are excluded from patent protection, like animal varieties. However, that does not mean that we cannot patent plants. As of 1 June 2017, there is a limitation that it is not possible to patent plants resulting from an essentially biological process. And that is in fact classical breeding, by way of crossing and selection, even if you would use technical steps to support that process, like marker-assisted breeding. But if you would apply a technical step that intervenes in the genome, like, for example, mutagenesis technologies, it is patentable. And that applies for both random and targeted mutagenesis, such as gene editing technologies. And then as an alternative, one could obtain plant variety protection for the new sugarcane variety. And from a PVR perspective, it doesn't matter how you develop the variety. So if it was by classical breeding or gene editing, that is not a relevance for that protection.
Mm-hmm. Thank you very much. So as backup follow-up, Japan actually is similar to the European situation where you can patent the microorganism as well as plant variety and also genetic sequences. For example, enzymes may be isolated from this microorganism, which may be used for this, natural nature of this microorganism. Then it's patentable. And PVR is also available for example, this kind of sugarcane that is also registrable under Japanese system. And actually, Japan provides both protection for the same, more or less the same subject matter. For example, plants, you can use the patent and PVR, like Fleur has partially mentioned. So we learned many aspects can be used for protecting BioBricks, but in Peru there might be some issues to be considered. So which is very informative. Now, okay, we have to move to the 2 questions in parallel because we are running out of time. So now we are going to move to the disclosure origin, which Begonia has mentioned. BioBricks has deposited bacteria Sporosarcina ipiacipi for patent protection under the Budapest Treaty. That is possible, which we've learned. But some countries needs to disclose the source of origin in the patent specification. I would like to know each jurisdiction what is the necessary obligation or no obligation. You can start, Fleur.
Yes, so from the European perspective, there is no obligation to disclose the source of origin in a patent specification, but there are systems in Europe where this is different, like, for example, Norway. And we have an EU instrument, the EU Biotech Directive, where the patentee is encouraged to disclose the geographical origin of the biological material that is used, but there is no direct consequence for patentability, which can also be different, as we will learn later on. Under the plant variety rights system, you disclose the geographical origin of the variety. However, this is more to provide information about the circumstances under which the variety was developed, and not so much about the origin of the material that was used for this purpose. Next slide, please.
So Daphne,
this
can you
is-
explain? Yeah, thank you.
Yes, this is the case of Peru. In Peru, it's mandatory to disclose the source of origin in the patent application. Something that I want to mention is it's in the format application, and it's not a requirement to include the source of origin in the description in the technical documents. Actually, the picture you have there is in Spanish, but it's part of the format of application you file in Peru, and actually you have to mention if you are using or not a genetic resources or a traditional knowledge and where it comes from. What happens in the practice is that when you file an application, the patent office normally conduct a quick review of the specification. And if they notice that you are using a generic resource, they ask you to inform as a requirement where it comes from. And they also require the contract, the access contract, right? And if you don't have it, or if you don't file it, what happened is that the application became abandoned. Because as I explained before, something that happened is that we are in the process of learning about that kind of contracts. So in some cases, they suspend the case and wait for the applicant to get the contract. Yes.
So it's possible to suspend
Yes.
prosecution. That's great. Okay, in Japan, no mandatory obligation to disclose the disclosure of origin. So it's in patent system, as well as we forgot to mention about the PVR system, but the PVR system is also similar to the one Fleur mentioned in the European system. So it's some information is disclosed, but that is not really a disclosure of origin. It's the same case for you in Peru, with respect to the PVR application?
Yes, well, because it's not possible to get an application if you don't mention where the variety comes from, right? So
Yeah.
it is part of the format, the application, the requirements to mention parental. So that part's like it's
Okay.
necessary.
Yeah, thank you very much. So we'd like to move to the third question, which may be sometimes very important, biopiracy issue and biopiracy impact on IP. You know, our case, BioBricks has not actually complied with its PIC and MAT obligations, which may be some problems. And it assumed that its collaboration partner in Peru had arranged for all relevant permits and documents. That's our premise. And does this impact IP position of BioBricks? And we have 3 jurisdictions, so we'd like to know the impact of this biopiracy issue. By the way, we have here the picture of the Nagoya Protocol, and it's some detailed explanation may be expected. But as an introduction portions, Martin has already introduced that we have already had a webinar in the last year or the year before. You'll be having a link to those webinar if you want to know more in detail about Nagoya Protocol is a practice or implementary practices. So we'd like to move to the this impact issue. What about the Europe, Fleur?
Yeah, so Europe is a party to the Convention of Biological Diversity and also to the Nagoya Protocol. Under the UPC system, there's no specific reference to your PIC and MET obligations, but there are certain national systems in European countries where there are consequences for your patent position in case of non-compliance, like for example, Norway, but also in the Netherlands, we have a provision in our Dutch Patent Act where it is provided that no patent shall be granted for inventions that result from biopiracy. However, it is important to know that in European Union, we have another way to encourage compliance with the CBD, and that is the European Access and Benefit Sharing Regulation that entered into force in October 2014. Now, that regulation is not so much about the access and benefit requirements for European genetic resources, but it imposes a due diligence obligation on companies conducting research and development activities in Europe using materials originating from Nagoya countries. And basically that means they have to seek, keep and transfer certain information and documents relating to the genetic resources, such as the place and time where they were collected. And they have to submit declarations when the development comes to a final product or when they apply for certain funding. And this has been enforced for a couple of years now. We've seen the first cases in Germany where companies actually have been fined. And in that respect, it's important to understand that the authorities expect companies to have at least, well, of course, the relevant information and documentation in place, but also to have internal policies, codes of conduct, active training programs for employees to make sure they are aware of their obligations, to appoint a representative in the company to a certain compliance, and also to have a proper administration to track and trace the material within the company. So these are really the factors that the authorities take into account. At the moment, I'm not aware of cases in the Netherlands, but it is, well, in the future, this may be different. Thank you.
It looks like time is running out, but Daphne, can you briefly explain your situation in your country?
Yes, okay. Yes, because of, as you can see in the slide, and I have mentioned, we are part of so many protocols and conventions, and we have Andean laws and local laws. So yes, we do handle, we do so many efforts for biopiracy cases. Actually, in Peru, we have is the National Anti-Biopiracy Commission that was created in 2004, and the job they have is to try to avoid two things: the granting of patents, as I mentioned, in the world that uses traditional knowledge, because then the patents they're not complied with patent requirements, and the other part is to try to avoid the use of genetical resources. It is a hard work because of there are many countries, most of the countries do not have the obligation for disclose the source of origin. So for countries like Peru, it's very hard to do the work sometimes to find in what countries and what companies are using genetic resources that came from Peru. Because if you don't mention the source of origin, you can say, for instance, that in your patent application that you're using a material named Yacon, which Yacon it's very popular in this part of the world, actually. But Yacon, I think there's Yacon in Ecuador, in Bolivia, and Peru. So for the authorities, it's hard to know if they are using or not Peruvian local resources. So this is why Peru, this is the reason Peru is one of the leadings in this changes of international law to try to change and to try to have the disclose of a source of origin as a requirement, actually.
Can I go to the next slide? Okay.
Yes, I already mentioned that.
Yeah, okay. Japan, as a backup, as a backup, Japan is a party to the Nagoya Protocol, and then, but Japan Patent Act has no mention about PIC and MAT, or even Nagoya Protocol is unrelated. Independent regulation is already implemented. So it's very similar to the European situation, but the requirement of the ABS system regulation is, I would say, less strict than in Europe, I would say. So now we have now to the conclusion remarks. So we have learned and we have studied, analyzed facts, hypothetical facts, and analyzed many aspects from the IP protection point of view. We have learned that there are differences in the form of the protection available for genetic resources and associated traditional knowledge. Microorganism eligible for patents in Europe and Japan, and I think Peru is also available. But in Peru, you need to comply with many regulations and requirements, I would say. So it's you have to be very careful in obtaining IP protection in Peru. And plants are eligible for patent protection in Europe and Japan, but not in Peru, I think I have learned. So, and then some overlapping subject matter or protection is available for patents and plant variety rights. But you have to be careful in wording and what type of embodiments that is available for protection of both systems. And then sometimes ABA requirements need to be complied with, but that might be indirect, effects in obtaining patents, right? And then the European Japanese system, there's no obligation to disclose the source of origin, while the some countries you have to satisfy with disclosure of origin. That's concluding remarks, and then we have learned many things, and we may go to the. We have briefly touched upon the plant variety rights, but in the next round in May, we'll be having a more detailed webinar on the plant variety rights, as well as other breeds, such as animal breeds protection system. So in Europe, especially. So if you are interested in this kind of information, please stay tuned. So now it's the case study session has finished. We have running out of time, but if you have any questions to ask to the panelists or speakers, including Begonia from MIPO, please send a question to the Q&A column. Or send an email. Okay, so we are running out of time. So unfortunately, we are enthusiastic to introduce many aspects from the case study. So we are running out of time for the questions. So unfortunately. So yeah, we are going to conclude and the seminar. So Martin, so it's floor is yours.
Thank you, Takeshi. It's no doubt that with this first webinar opens our minds what is coming. And we already have, first of all, want to thanks, first of all, Ralph Knack, who is the standing committee responsible of this committee, who provide us all the support to organize this series of webinars in the last 3 years. Well, especially to you, Flor, Daphne, Begonia, and Takeshi, because you have a marvelous work and invite us in this universe and how it's coming. Flor has been telling us this is linked to sustainability. And it's, I think, how we started thinking about IP. And it's, I think, an excellent example, this case study, how will be linked with all this universe. Thank you, all of you. And also because you put, it's a very good Netflix series for the next webinar that we're going to talk about protection of plant varieties and animal breeds in Bulgaria, identification of good practices. Silvia Dolorova, she's an expert on that, but also the IP protection and genetic resources in Croatia by Ivana Kunda, two specialists as yours that will complete this scenario of these two first webinars and get prepared for the second section about cultural heritage. No doubt that with the wide participation, we'll also participate Damian Zographos at that section. We will talk about cultural heritage that is all inside this cultural concept. So I invite all of you, please continue participating on this. And for the next events, I understand that you see the date on May 30, we'll wait you. And for the next events, for ACP, as you know, and all Matthias mentioned, and I also appreciate that he's here. We have this meeting in Quito. Today is the last day for the early bird. Be hurry. And to attend the Istanbul Congress that will be very lucky and fortunate that because we have a panel on this topic in this Congress. So I'm more than excited to see you, all of them there, and with this great team that we are working in the committee. Thank all of you. Unless Cinzia have any other recalls, I really want just to thank all of you, to all the speakers. Great. I know what we have been surrounded by celebrities, and I look forward you for the next webinar on May 30. Thank you very much. Thank you all. Thank you, APPI. Thank you, ACP. Bye.